now those things like resale are probably.
I mean, there are a lot that easy because you can go for probably $2 and watch a game there cheaper than.
Yeah, but now I'm trying to.
Oh, shit, the Cubs are Red Sox. I saw the Cubs and Red Sox this past spring, but 2 years ago, which was fun.
Is that new?
It's not new. I went,
But anyways, great, tall and have a great.
I actually went by that house. That house is built like,
It's nice.
oh my
I
gosh,
bet
it is a beautiful
it
house.
looks so much better now.
Yeah.
Where is it?
52 Shiloh Road?
Oh, okay.
You're on. Okay, I guess we'll go ahead and get started. My eyes say it's 6:30, so please join me in the pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have 4 of our 5 members, so we're good. And will not be voting on anything tonight. So I will start with just kind of a quick introduction of what we're doing tonight and hopefully why you're here. So we have been in the process, and we've been doing this for the last 2 or 3 years, of making some changes to the land use ordinance, trying to update it, bring it in line with, modern times, also what the state requires, and also areas where we've had problems with, or confusion, maybe is a better way to say that. So the process has been that we met back in, I think, July with the chairs of the various committees and worked with the select board, and the select board gave us kind of our marching orders. These are the things we'd like you to work on. So the planning board, that was codification as the primary, and codification is a new format to the land use ordinance. And so it is not a lot, in and of itself, it's not a lot of changes to the land use ordinance, but it kind of puts everything in the right categories, gets rid of, some conflicts, and we hired a consultant pointed out some conflicts and things that are confusing. So some of it is as simple as use the term select board. In the past, it's been select person, select board, what's the right term, some is's, one to ours, some really simple stuff like that. And then they also pointed out where the things where we are in conflict with the state law. So tiny homes is an example. The state has implemented rules on tiny homes that we don't have. And so the code enforcement guy has been issuing permits based upon the state law, and so we're trying to clean some of that stuff up. And then again, like I said, there are some things that, minor policies that, and you'll see some of those this evening, where it's just been confusing who's responsible for what, or maybe we're a little out of date with what's going on. So with that, so select board gave us that mission. We started working on it as a planning board with Mr. Tamarj, if you haven't met him, our excellent town planner, went out, dug up a bunch of information for us, put some samples together. So we've been working on some of the stuff that you're gonna see tonight and in future meetings for, I guess, 2 months plus, August, September, and now into October. And so the step we're on is to do informational meetings, public informational meetings, so that you have a chance to see what we're doing, ask questions about what we're doing. This is not a formal public hearing, so we'll do a couple of those, work our way through the changes, and then the planning board will put together our recommendations on changes for the land use ordinance, send it to the select board, and the select board will then say, yes, this is what we want to do, we like that, change this, and then send it back to us for a formal public hearing. And then once that public hearing, and once they do that, the verbiage starts to get locked in. But then we have a public hearing, and then it goes before the town meeting in July, something or other this coming year. So it's a little bit different in that regard. So we'll have another meeting to cover other parts of the land use ordinance changes in November 15th, I believe, is scheduled for. And so plan to, if you don't have anything going on November 15th, and you're interested, come on back. And we'll go over some new stuff. We might also go over some of the actions we've taken upon your comments. So the process this evening is, Mr. Tabarge will do a better job of explaining what I just said, and then we will go one by one on the minor, what we call the minor policy changes. You'll have an opportunity to come up and ask questions, address your concerns. We may or may not get them answered this evening, but we'll take notes on them, and then we'll stop the public process, and the planning board will then mull over it and give Mr. Tabarge some guidance on how to go forward for the next step. So if that makes sense. And so that's what we're gonna do. So if it's your turn, if you wanna speak, please come up to the table, or you can sit in the front row. We do no longer have microphones. So the only microphone is on the camera back in that corner. So please, you don't have to look at it, but please speak loudly, clearly enunciate what you're saying slowly so that we can pick that up. Because we use that if there's any questions about what did he or she say, what do you think they meant by that? And you'll start off with your name and address. And with that, I'll have Mr. Tabarge, he's leaving, give a quick update on where we are and start off with the first minor issue, please.
Thank you, John. I just wanted to mention, if anybody didn't pick up one of these on the way in, these are summary sheets of each of the issues that are posted on the website, but we printed up some copies tonight if anybody would like them. Yes?
Oh,
Can I have one? Everybody got one?
yeah,
Okay, great.
thank you.
You can't leave unless you've signed in. So please sign in on the way out the door if you haven't
So
already.
what I'm gonna do is kind of get into a little bit, not in the weeds, but at least in the trees to show you what is involved in this. And these are summaries, and if you go to the website, you'll also see actual draft language, but for tonight's purposes, I think the board wants to just give the general policy guidance and direction, and then have people kind of indicate, yes, this is makes sense, or there are some real concerns with moving in that direction, and then obviously we kind of take a deeper look at the policy before getting into the details. So, the overall project, as John said, the town has hired a consulting firm that does ordinances for about 34 towns in Maine, and they have a digitized framework. You may recall that a couple of years ago, the town paid to have the tax maps digitized, and those are now available online for citizen access and use. And this is kind of the same idea. Right now, we just have a PDF on the website of the ordinance. You have to download the whole thing. You can't really cross-reference or do searches of those sorts of things. So this will make that much more usable for the general public. So as John said, they've completed what they call an editorial and legal analysis. And in that process, they identified both typographical errors, not just terms you call it select board or select men or other, but just plain typographical errors, missing words, misspelled words, those sorts of things. And grammatical errors where the language just doesn't make sense the way it's stated. So based on all of their research and other ordinances, they're going to be proposing corrections in those areas. And then as John said, there are just some places where the town is just not in compliance with state law. And one that we're going to deal with, and I'll address a little bit tonight, is manufactured housing, because there have been significant changes in that realm. So, as John also said, this is an opportunity for the planning board to address some issues that come up frequently during subdivision reviews and application of the ordinance, where some areas are just plain confusing. And we'll kind of show you a few of those tonight. And the goal is to eliminate the confusion, improve efficiency, and address some of these issues that keep coming up in an ordinance, in the review of the projects, and the ordinance just doesn't deal with them. And so the idea is to have the codification, that mechanical part, as one warrant article, and then put these policy issues as a separate warrant article. And then as this process goes forward, presenting these to the public, if any of them, like the tiny homes or anything like that, kind of gets sticky in terms of the public process, people have real concerns about it, there is always the option of pulling that out of these minor policy issues and dealing with it separately, either in the next town meeting or putting it off until after that. So that's kind of the goal. As John said, there are going to be 2 public meetings. This one, we're going to focus on these minor policies, but then there are some administrative changes that we'll be dealing with at the meeting in November and explaining those. So the first of the policy issues, if I get that to advance, is backlots and private ways. In many communities, they have provisions for backlots and they have provisions for approving a private way. And typically a private way is a situation where someone is developing several lots, a family in particular, but they're not, they don't have the capital resources or the intent of developing a subdivision to sell lots. And so state law provides exemptions where people can do multiple lots, and most towns have a set of provisions called private way standards that really focus on the creation of the road. It doesn't get into all the issues that subdivisions get into with water supplies and wildlife studies and all of those things. It just focuses on making sure that the road that's going to serve these lots is properly built, doesn't cause drainage problems for neighbors, and it's a much easier process, but it is a legal process because you're creating a de facto subdivision in terms of the road. So making sure that it has a maintenance agreement and those sorts of things. The problem with the current ordinance is it mixes these.
George, before you go to, would you
Yes.
just, does everybody know what a backlot is?
No, I was gonna
Would you
ask
just
that
guys-
question.
Okay, yeah, so a back lot is what some communities call a flag lot, where you have like 350 feet of frontage. You need 300 feet for each lot. And you've got 6 acres of backland. So you can't really, you've only got 300 feet of frontage. And you're just gonna give a lot to a relative. And so you can create a 50-foot right-of-way or actually deed a 50-foot strip to the backland. And basically, as long as it's at least 5 acres, that's a buildable lot with just 50 feet of frontage. Okay, so that's what's called back lot or flag lot. And again, that's just for a single lot. And so this ordinance has that provision, and we're not really going to change that other than to clarify how it's differentiated from private ways where you have multiple lots. So that's kind of how this goes. So let me just give you the rules for back lots, and I think that may kind of answer some of those questions. So dealing with what's above the black line. So currently, a single back lot, it has to be at least 5 acres, and it has to have that 50-foot strip, and those are approved by the code officer right now. And really not proposing any change to that basic rule, other than the access currently requires someone for a single house to build a 20-foot wide road. You could have to go back in 500-600 feet to get to the point where you can actually build, or longer. And so the people have really expressed concerns that it really makes the back lot undevelopable because of the cost of putting in a full road just for a single house. So the proposed change is to reduce that to a 16-foot driveway, because it's only going to be serving one lot, and that, under the draft provisions, the fire chief will sign off on that they can service it in terms of it's not going up a 20% grade around, they can access it with the emergency vehicles without causing damage to the emergency vehicles. So that's, and then the whole provisions for backlots, currently, the lots are approved by the code officer, and depending on which code officer people have dealt with in the past, some code officers have applied a 2-acre lot size for those back lots in the multiple situation. Other code officers have interpreted the ordinance to require a 5-acre lot. And so it hasn't been applied consistently. This proposal is to take that out of the code officer's position and put it before the planning board as part of the rest of the formula for these private ways. And the planning board discussed whether to, try to apply the 5 acres or allow 2 acres, and felt that in order to justify the cost of multiple backlots and building a road to serve it, really 5 acres made it unworkable financially. Currently, the road itself, the lots are approved by the code officer. The road commissioner approves the road. There's a plan that he signs, or she, and again, the 20-foot road is required. That would be continued, except that under this proposed overhaul, it would be approved by the planning board rather than by the road commissioner. And then finally, the maintenance agreement currently, so we have the code officer approves the lots, the road commissioner approves the road, and the planning board approves the maintenance agreement. So people are confused within the organization, who's doing what, who's responsible for what, and property owners that are trying to use this are very confused in terms of the process. So as I said, most towns deal with these with a straight planning board process. The planning board will look to the code officer to make sure that the lots meet the zoning requirements. The planning board will look to the road commissioner for input on the road design. And then the planning board itself, working with the town attorney, can look at the maintenance agreement that's required for these. So that is pretty much the proposed change, what's in the ordinance currently and what's being proposed.
Okay. At this point, we'll open it up for information, so if you would either come up to the chair by the table or sit in the front row, state your name, address, and ask your question, make your comment, so.
Michael Abbott, 51 Garage Lane in Durham. So I have a couple of questions, just more or less clarification. When we're talking about backlots, I'd like to know if that's distinguished from landlocked property, which means a piece of property that currently doesn't have any road frontage or access. Could that then be considered a backlot? And if they were, able to obtain the right of way and driveway from adjacent landowners.
Yes, if they had the 50-foot right of way to a main road, then you could solve it from being a landlocked parcel. So it wouldn't be exactly the same thing as a
Right.
typical backlot, but it could be applied in that situation.
And when you say a 50-foot right of way to a main road, so that's a 50-foot right of way to a road that's up to town standards?
Not necessarily, no. Any road that's recognized as a road. Some roads in town are substandard. We have some state highways. So the backlot provisions apply on any recognized road within the town.
So if a backlot is approved and is granted a 50-foot access, a 50-foot right of way, and a 16-foot right of way, could that then another piece of parcel be added where could access then be granted from that new driveway? As I'm saying, you could kind of spaghetti.
Well, what would happen is then they would be kicked into the private way. So if it's gonna be serving just more than one lot, then they would have to get that upgraded to a private way with a maintenance agreement and have that approved by the planning board.
Okay, so back to my previous question. That 50-foot right of way and 16-foot right of way has to come off you said any road, but
Yep.
it has to be, it can be off another driveway? Another,
It would have to be something that is recognized as a road in the town ordinance.
okay, I guess I'm just not clear on what the definition is of a recognized town road.
Private or public.
Well, there are both private and public ones. Obviously, the state highways, you could come off state highways.
Of course,
You could come off a town-maintained road.
right,
You could come off a private road if you have the legal rights to use that private road and can confer them to others, depending on the details of the deeds and the easements.
okay,
So, but it would have to be something that is recognized as an official legally sanctioned road, as opposed to coming off someone's driveway, yeah.
So once that back lot is granted a right of way and a driveway, that doesn't automatically become a new private way that can create
No,
access
it
to
doesn't.
another back lot.
Not if it's approved by the code officer under the backlot provisions. Anything more than that, he would look at it and say that will become a private way, and whoever's developing it or expanding it would have to go through the process of getting it approved as a private way.
So, and sorry, but just to make sure I understand, access can only be granted from a recognized road, not a driveway, but a road that's, I guess I'm still not 100%.
The town,
It's a legally established road.
Legally established
Correct.
road.
and the town, correct me if I'm wrong, the town has a map with both private ways and public roads.
Yes, there is a street map of the town that points all of those out. The ones that we're aware of, yeah.
Okay, so obviously the state roads, the town maintain roads.
Yep.
But driveways,
Not a driveway, it has to be a private road.
a private road,
Correct.
okay.
And you need to look to the town street map
The
to
town
find
street
that.
map distinguishes those.
Yeah, just because somebody puts a sign up saying Talbot Way doesn't make it
Right.
something you can use.
Okay,
And I think before we get too much detail on a site specific, I would recommend that you, before you buy it or do anything else, you talk to the codes guy and the town planner to make sure, you know, what we're gonna do, just an informal discussion.
okay. Well, okay, I'm just glad to understand that this doesn't open up, you know, a driveway to one driveway to another driveway, which I know that was sort of turned down at a previous proposal, so, okay, excellent, thank you.
Thank you. Next, Chief, did you want to speak?
I just have a quick question.
This is the town map that offers the roads. First, a question for him?
Thank you, Georgia.
That's what I need.
Yeah, come on, come on up, and then you can start with your name and all that stuff, so. Same thing, your name and address?
I'm Heather Roy, I live at 777 Hollowell Road, and, George, when you started talking about multiple backlots and multiple backlot access, and you started the conversation about, families that potentially wanna be able to, you know, divide their larger parcel, I think if, it would be good to clarify at what point, whether it's family or not, that goes from a multiple backlot situation to be required to go through subdivision review.
3, right?
Okay, so the way the main statutes are drafted and adopted, which the town's subdivision regulations go the same. If you create 3 separate parcels in any given 5-year period, that is a legal subdivision that requires approval by the planning board through the subdivision process. Now, there are exemptions that are stated in the subdivision law and in the land use ordinance, so that if you are giving a lot for, I think it's less than 50% of market value to a blood relative, and there are certain relatives that count, then that is not, so you can create 2 lots plus that lot and not trigger subdivision and have to go to the planning board. But if you need to get road access for any of those 3, then you would have to have it approved as a private way, just simply to create the legal road access and frontage.
Thank you. I just think it's important to clarify that so that people aren't hearing they have 50 acres of land and they can give it to they can give 5 parcels to their family and that subdivision review wouldn't be expected.
It may not be, if they were all qualifying exemptions, they would have to get approval of a 50-foot right of way, however.
And so if someone was in that situation, do they come to you or the code enforcement officer to determine if subdivision review is required?
Typically, they start with the code enforcement officer, and then the code enforcement officer would refer them to me.
Just some feedback, I think it's a beneficial thing to have that process like really clear on the website so that when people are questioning what pathway they're supposed to take and who they should go to, having that really clear is, I think, really important.
Yeah, first step is getting it clear in the ordinance, which
Right.
it is not right now.
Thank you.
Anyone else? Please.
Let me follow up that one. Prakash, Lane. Just to clarify, the 16-foot driveway, what I just heard earlier was it needs to be a town recognized road. So would you consider changing the language to make it clearer, a 16-foot road?
No,
And why
that,
is
that was not what was, my understanding, that was not a question. The question was, could you put a backlot access onto a driveway? That was the earlier question. The answer is no, it has to be a road. So the 16-foot driveway is just the access to the backlot. It's not the creation of an easement. Because right now it requires within that 50-foot access to build a 20-foot wide road for a single house.
Okay, I found that confusing.
Okay.
This isn't.
Yeah.
It read to me that it could be off a 16-foot driveway. Okay. Thank you.
Anyone else on backlots? Going, and we're not gonna bounce back to it later, so your last opportunity,
But we can come back in November.
you may come back in November, or you may, it's good time as any, say you may text, or not, excuse me, email, Mr. Thabarge with another question you have, and it'll come up at the 15th November.
Thank you.
Ms. Roy,
This is just about, so I think it currently reads that it has to be 20 feet with with shoulders. Is that, so is that staying? Is it 16 feet wide with shoulders? Sorry, maybe that's in the weeds, but, you know, I think that's important to know too.
I just. Give it shoulders
I think it's just 16 feet.
And will that require a turnaround?
Road surface.
Yes.
16 feet of road surface.
Yeah.
Slopes and ditches are not part of the 16 feet.
That's correct.
did that answer the question?
It did, thank you.
Okay. Last one, gone. All right, next topic, please. Oh, no, sorry, the planning board discussion. Does anybody have any comments on what was said, or your own particular comments about this?
One of the reasons that we certainly looked at reducing the road surface of 20 to 16 feet was the financial burden on the homeowner. And I know certainly within my neighborhood, there's one individual that they initially went with the 16 foot and found out that they had to go 20 feet. And it's unfortunate that another year hadn't gone by. Hopefully this would get approved and they would have had to circumvent that additional expense. But I see that as a very good improvement for the townspeople.
The chief has left, but it's important to note, he was in on the discussion, and so he concurred with the 16 in this case and the 20 foot for the other one. Brian, the chief being fire chief. So, okay, if not, we'll move on to the second item, Mr. Thabarge.
Okay, next issue.
Non-conforming?
Is the non-conforming structures expansion. So currently, the ordinance is a compilation of provisions that were copied and pasted from other ordinances. And unfortunately, whoever did that process didn't really tailor it to be applicable to Durham's situation. And so, for example, this first box talks about how if your house is too close to a property line, doesn't meet the setback, then you're limited to an expansion of 30% of the area of that building.
I'm sorry to interrupt.
Yes.
Does everybody know what a non-conforming structure is?
Something that does not meet the zoning requirements, okay? And so the planning board then decides, under the criteria of the ordinance, is this gonna cause a drainage problem, traffic problem, noise problem? All the things that are typically applied to businesses being located in a neighborhood. There's just not a conceivable reason why the planning board would stop someone from putting an addition on their house for any of the conditional use criteria. So, and then if they can't get the conditional use approval, or they wanna go more than 30% without limitation, they go to the Board of Appeals, and the Board of Appeals, the only thing that they can look at under the ordinance is the groundwater impacts. Again, there is, the town, the state has a plumbing code that addresses septic systems. It just, and if you're, whether you're in an aquifer or not, you still have, that's still the only criteria that the Board of Appeals can apply. So if they meet the main state plumbing code, what grounds is the Board of Appeals gonna say you cannot expand? So it doesn't make any sense, and so that confusing language will be removed as part of these amendments. And simply, the criteria will be, right now the ordinance says, in addition to that, for an expansion of a non-conforming residential structure, they have to approve the foundation location. And that was copied and pasted from DEP guidelines for lakefront development, where it makes sense that if you've got a building, a camp, that's 20 feet from the water or 50 feet from the water, state says you gotta be back 100, that provision for the planning board review of the foundation is where that language came from. But again, it makes no sense if your house is 20 feet from the property line, it's supposed to be 50 feet. What is the planning board gonna look at in improving your foundation location? So this would basically say, as most towns do, if the code officer looks at it, you have a house that is 20 feet from the property line, it's supposed to be 50 feet, you're putting an addition on the back end of the house that meets all setbacks, then the code officer can approve that without going before any board. That's how it's done in most towns, and that's how this language would be changed. And then finally, there is currently in the ordinance, planning board looks at if someone discontinues a non-conforming use, which there aren't really very many in town, and they can get a 1-year extension of the time into which it was discontinued, that you can reestablish it after that year is up. Usually it's a year, they can extend it another year if someone comes back and wants to reestablish it. The planning board, the Board of Appeals typically handles non-conforming uses and expansions, so this would basically shift that responsibility to the Board of Appeals. So only the Board of Appeals and the code officer would be involved with non-conforming uses, structures, and lots. So that pretty much is the limit of the proposed changes, just to clarify the process and clear up some confusing language in the ordinance that is not workable right now.
Would anyone like to speak on this topic? Seeing none, planning board? I guess, George, if maybe provide edification or the folks at home. So the original approval for non-conforming use is, who's the approval authority?
Well, a non-conforming use by definition is something that does not meet the zoning requirements. So typically, when, like, for example, the Resource Protection District got expanded, and we specifically pulled all of the buildings out of that proposed boundary so that they would not be put into a non-conforming situation. So the only time you're gonna have a non-conforming use or structure in this town is typically gonna be someone whose property was developed decades ago, maybe a century or more ago, and the house is built very close to the road. It's not at the 50-foot setback. So that's a typical, now who makes that determination? Typically the code officer requires someone to submit in their proposed building plan what the setbacks currently are and what they're proposing to, where they're proposing to build. So it's usually the code officer that looks at the question of is this conforming or not.
It could have come up if you go to sell, if someone is selling, the title company does a survey,
Right.
and they're gonna say, hey, you're only 20 feet away and it's supposed to be 50. How do they get what's the approval process for non-conforming?
Well, if the house was built in 1850, the title companies, the surveyor, everybody's gonna recognize that's been there for 150 years, long before the town ever had zoning. So there's really no question that that is lawfully non-conforming. If something was built in 1980, and violates the setback, that usually triggers a review by a title attorney to say, was it built in violation of the setback? And then it's illegally non-conforming, not legally non-conforming, and there's a whole process for dealing with that as well. So typically it comes up, like you say, with a mortgage survey, or someone wants to get a building permit to do an addition, and it's discovered at that point.
I think there's an example of that recently came up, maybe within the past year or two. I think there was somebody that was buying a property, it was a corner of Rabbit Road and 136. And the title attorney found that the house was too close to the property line.
Oh,
And they went to the select board, I believe, and the argument from the owner at the time was the road commissioner dictated where his driveway should go, and that's what caused the property to be closer to the, so that's how that process went, I recall.
And as I remember, it was also a previous, or a couple of times previous code guy said you measure the right of way from the middle of the road, or, whatever the point they gave them, it wasn't the correct point, it was from the edge of the right of way, and I think, so they had to go get a letter from, a letter from the select board that said, we're not gonna enforce the fact that you're non-conforming. So that is also another way to.
Yeah, and the more recent one that you pointed out, this brings up, the codification's gonna fix something. Sometimes it's the ordinance is confusing. The definition of a setback says from the property line, or right of way of the road. The provision where it sets the setbacks in Article 3 says setback from property line, doesn't mention right of way. So unless you look at the definition, which the code officer didn't in one case, you're gonna say it's from the property line. So the codification is going to add that statement from the definition to the other place so that there's no confusion. And it doesn't have that mistake, where one part says one thing, another part doesn't say it.
And then does it have to be the Board of Appeals? I mean, I'm not saying that's wrong, but that's a question that
Are
may
you
come
saying
up.
like in the case where the select board was doing that?
No, I'm sorry, we require the select board to approve, I'm sorry, not select board, the Board of Appeals to approve some of this. So time limit extensions, Board of Appeals, I guess that's the only
Well,
one.
what happens is under the ordinance, if someone discontinues, like there was a business on Mill Road, it was like a commercial garage on the left, just the second property in, and someone abandoned that as whatever, if it goes more than a year abandoned, and someone came in and opened a business without coming to the town for conditional use approval, and they were claiming that they had the right to because it was a business there before. Well, once it's discontinued for a period of a year, they forfeit that right to continue that business there without conditional use approval. And so what this does, someone has the right, the opportunity under the ordinance to extend that for a second year, but the Board of Appeals has to look at the circumstances and they determine whether it's a legitimate, they were selling their property, if they were a month over the year, the Board of Appeals can grant relief, but they look at all of the details of the circumstances.
Yeah, I think my question is more specifically, why would that have to be the Board of Appeals versus the planning board for that approval?
It's just the type of thing, in the same way that Board of Appeals don't review private ways typically, or subdivisions, non-conforming uses, variances, all of those things under state law are handled by boards of appeals, so.
Okay, answer my question, I think I saw a hand.
Yeah. Oh, but are we past the part where we're allowed to ask questions?
I will make one exception,
Okay.
and everybody does get one exception.
We're talking about non-conforming use. Is that when there's no conditional use of permit that already exists? So like, if a property has a conditional use permit and the business isn't operating anymore, but they have a conditional use permit, does that conditional use permit go away if that business isn't operating?
Okay, so what we have to distinguish, this is really complicated.
Okay, we don't have to talk about it. If that doesn't apply to this, I can just ask you privately.
Yeah.
Okay. I'm not-
Conditional use approvals, run with the land, but there are businesses that have been here for 75 years that never came for a conditional use.
Right, okay,
Those would be hit by this.
okay.
Yeah.
Thank you.
Okay, anything else from the planning board? If not, Mr. Tavares, next topic.
Okay, next is subdivision road buffers. So this proposed revision, very focused, would say that right now, if someone puts a subdivision along a road, they have to install a 50-foot buffer, the lower graphic on the left there, between the existing road and the subdivision to screen the views of the new housing. However, if on the right graphic, you put a road beside people's houses as part of a subdivision, there's no requirement for buffering. So the planning board discussed whether it should be automatic, and I think where they came out, if there's 100 feet of woods there, it doesn't make sense to require them to put in a 50-foot buffer. If there's 100 feet of open field, then it does. And so the draft language gives them the authority to require a buffer if they deem that it's needed. And it would be similar to if they were reviewing a commercial project, where they do look at where buffers must be required by the developer. So that really is as I said, right now, 50-foot buffer is required for between the subdivision and the road, and there's no change on that, but no buffer is required between the new subdivision and the existing homes of the butters, and this would give the planning board discretionary authority to require that buffering.
Okay, any questions, comments? And you can say you disagree and it should be 100 foot or 200 foot or any of these, you may have a recommendation to say something different in the ordinance. So, any comments from the audience? Seeing none, going, gone. Planning board?
Just the one thing about buffers is we certainly take a lot of the input from the abutting owners, and they're notified when they're doing a subdivision like this. So we listen to what their concerns may be and take that into consideration.
I just think it's gonna be a great addition to the ordinance.
Excellent. We have at least one happy camper. And I want you to know that this has been discussed a bunch of times in previous meetings. So just because you're not hearing a lot today doesn't mean it hasn't been discussed prior to today. And so I drove through a subdivision today where this was an issue when it was first being approved. But even with the leaves gone, and the existing subdivision had fairly deep backyards, well vegetated, and I think it was a 25 foot, but there's, I guess at the end of the day, the planning board said, hey, those two together will be more than enough, and so sometimes it's just wide open fields and you gotta do more, so. Okay, subdivision road buffers, on to noise standards.
Okay, this one's a little bit more involved, as you can see by the number of table listings for the different topics. So currently, the town has a noise ordinance that applies to all properties within the town. And it pretty much just applies a typical residential zone standard to all uses. And we have businesses scattered throughout the town, some with machinery, and it's just really not a workable thing to limit all businesses to a residential property sound level. So one of the things that it does is to differentiate between three classes in Durham that currently exist. That would be residential, agricultural, and business. And then secondly, it gives more specifics on the testing protocols that I'll get into as we go down through the chart. And finally, clarifies when a sound study is needed. So the first issue that we looked at was the hours that these would be applied. So most ordinances have a daytime noise level and a nighttime noise level, understandably. And currently, the standard is daytime is 7 a.m. to 7 p.m. If you think about summertime, and people, especially in the construction industry, that are doing working on houses and things. This would propose to change it to 7 AM to 9 PM would be daytime hours, and nighttime hours would be 9 PM to 7 AM. And that's very typical in many communities, as I mentioned. Currently, all land uses are limited to the residential standard of 55 decibels per day and 45 at night. This proposes to give higher sound limits, recognizing agricultural equipment as well as commercial would go a little bit even higher. The measuring method right now is outdated, and you really need to look at how a sound study actually proves that a sound is either in compliance with the ordinance or violating it. And really, it takes a qualified acoustic engineer to do a study that will stand up in court. You can't go out there with your phone and measure the decibels and have it stand up in court. So this would establish what are the protocols for developing an enforceable sound determination. And then also the ordinance mentions nothing about impulsive sounds, and those are ones that aren't on a continuous basis, happen infrequently or irregularly. And this does establish, based on the town attorney input, a maximum for that of 75 decibels. Construction noise currently, you cannot have any construction noise between 9 PM and 6:30 AM. Recognizing what we talked about up above, this would be updated from 9 PM to 7 AM. And noise studies, there's nothing in the ordinance right now that talks about doing a noise study. This would clarify when they would be done. If the code officer is going to enforce against somebody's property and activity, or the planning board is going to limit someone's right to use their property for a business use on the basis of noise, then that would trigger a noise study to establish either compliance or non-compliance, or meeting the conditional use criteria or not. And that must be conducted by a certified acoustical engineer, and they have to get a baseline measurement of the ambient noise level, they call it. They have to identify the source, do an impact assessment, and propose potential ways of mitigating the noise. And the ordinance mentions nothing about mitigation of sound right now, such as putting in a sound barrier, putting it within a building, having operational time limits, or requiring them to use quieter equipment. And then finally, the ordinance does have some exemptions, but if you look at other ordinances, there's probably some uses that ought to be exempted, such as emergency vehicles. If you live across from a fire station, you might think that they shouldn't, but that is a recognized necessity in most communities. And then temporary activities that have special permits. So that's pretty much a comparison, what's in the ordinance now and what's being proposed to be added or changed.
Would anyone like to comment or question on this?
I have a question. I'm Cass Steinke on Sand Hill.
Okay, just speak loudly, ma'am.
Pardon?
Just speak loudly.
Okay. The question between agriculture and residential, how do we determine that, or where do you look for that?
In the ordinance definitions,
Okay, but I'm looking at properties, like when you look at a map. When you look at a map, and you know where houses are, but right now there's 31 acres and the houses are all by the road. What is in the back, is that considered residential or is that agriculture?
okay, so property is not considered agriculture. Agriculture is a use of property.
Okay,
So if it's just woods, it's not agriculture. If it's just field that no one is doing any agricultural activity on, that is not agriculture.
okay, what about forest harvesting?
Forest harvesting is a different class, that's not agriculture, that is forestry.
Okay, so when that is being done, what is the noise level?
It would fall within those, that would be probably commercial.
Okay, and so even though it's backing up to 25 homes.
Yes, so this would establish that at the property line during the daytime, the noise level could not exceed, except for intermittent, but a continuous, like someone grinding stumps for 5 hours, at the property line, that could not exceed 65 decibels, or it would be a violation of the ordinance.
Okay.
Does that answer your question?
Mhm.
Any other questions? Planning board,
I know you talked about fireworks and how that plays into
I
this.
would like to discuss fireworks and some other stuff.
Recreational, yeah.
Would you like me to discuss?
Sure.
I have 3 concerns, and, thank you. Which is blasting, and I'm looking towards exemption, so one is blasting. And because that's a fairly controlled process to act, the Dugas pit out there, the state is very controlling on that, but blasting those with noise, probably exceeds that, and I'd like to exempt it. The other is fireworks. And then the third is, I don't think you all have seen it, but in the draft, which you'll get a chance to look at later, the draft article that would get voted on at the town meeting, it gives an example of impulsive noise, hammering or gunfire. I am concerned, I guess I would like to just make it short, I'd like to exempt those 3 things from noise. And there is, Brian handed me the state rules on times and all that other kinds of, which is what Durham doesn't have its own fireworks ordinance, so we follow the state law, which gives the times on regular days, special holidays, does not address noise. So while fireworks are allowed under the state law, it doesn't address the noise. So I would like to exempt fireworks during that, I think it's 9 AM to 10 PM maybe. Except the 4th of July, which goes to 12:30 AM. So it's not something, I just throw that out there, and something that we probably need to give Mr. Tabar's guidance on or not. Other feelings on those 3 topics.
And John, I don't think that we can exempt, well, we could exempt fireworks from this, but I would think we would be stating that we follow state law.
For yes, my concern is that this says you can have fireworks, and there are people in town who have a good reason probably that don't want any fireworks. And so you run into the time, okay, it was fired off, before 10 PM at night, but you exceeded the noise. Perfect example is my neighbor, I sit on my patio and I get a free fireworks display that was better than the city I used to live in. So I don't wanna see some issue where we are restricting that or fighting that, that kind of thing because of noise. And I don't know if my guess is it may very well exceed that, but he follows all the rules, so that's the reason I'd like to exempt. I'm not exempting him from the 9 AM to 10 PM and the rules about safety and all that other stuff. But I am concerned about putting a noise limit on it, and the same with shooting. And I don't know what a gun, I do know that not far from my house, there is some folks have a shooting range. They let the neighbors who are moving in before they bought it, and actually the neighbors bought it from them, said, hey, we shoot here, and as soon as they moved in, they started complaining about noise from the shooting range. So, although it's perfectly legal, I don't want to create an issue where, hey, you're perfectly legal to shoot your gun, but you gotta buy a silencer. A bit of an exaggeration, but that's my concern. That's why I would exempt those things. We have a lot of hunters and shooters and other folks in the town, and I don't wanna create an issue where maybe they're illegal now doing what they and their family did back in the days with muskets, but, so that's I'd like to exempt those 3 things.
So firing ranges specifically, and you're not gonna exempt hunting, but firing ranges?
Yeah, I mean, somebody who's just out zeroing their rifle prior to deer season, or they're just shooting recreationally or whatever. And they're following, I'm not exempting them from, you know, don't shoot your neighbors into your neighbor's yard, or like in the paper where somebody shot into somebody's house on a drive-by.
Oh, yeah, water.
But it becomes the noise issue.
Can you just clarify, because you just said the time, for the timing, so are you exempting it from all times? Or just?
No, they would have to, if, there's, the state law says you can do it on a what they call a regular day between 9 AM and 10 PM.
Right, oh, okay,
So it'd be exempt during that time,
okay,
that's it.
just
No,
I just wanted you to clarify, so from 10 PM to 9 AM, it is not allowed?
on regular days.
Right.
No, it is allowed, I'm sorry, fireworks are. Between,
No, but overnight,
yes, I'm sorry, between 9.
that's why it was.
Let me go, let me,
That's why
let me
I-
make
Fourth of
sure.
July.
Yeah, well, okay, so on a regular day, fireworks may be, this is the state guide. Fireworks may be used between the hours of 9 AM and 10 PM. So it is, those hours it's okay.
Okay.
Except on the following dates, they may be used between the hours of 9 AM and 12:30 PM on the following day. July 4th, December 31st, and the weekends immediately before and after July 4th and December 31st. So that's the hours that I'd like them to be exempt, not 2 in the morning, not 11:30 tonight.
Just clarify.
But no, thank you, so make sure it's clear. So do we wanna talk, next meeting, go into a little more detail?
Yes.
Okay.
What do you mean by hammering?
I would assume honing a nail or jackhammering. It doesn't say, it just says hammering. Yeah, I would assume somebody who's, I mean, I don't have enough muscle to make a lot of noise when I'm hammering, but somebody who's using a nail gun or something like that, and I struggle to think that it's gonna go beyond 75
So
decibels.
the definitions that you're referring to are posted on the website. So if all the board members will take a look at those definitions.
Pretty much, I missed that, George, thank you.
Yeah, we can dig into that
Yep.
at the next
I
meeting.
just, for the benefit of the folks here today and whatever, my vote would be to exempt those activities inside the legal hours that they can do it.
You gave 4, actually. You gave blasting, fireworks, hammering, and gunfire.
I guess I didn't give you hammering. The hammering is in your draft article, George.
Okay, I'll take a look at that.
I just don't know how much.
You take a look at that.
We have a construction guy. Do we make a lot of noise hammering? If you live in a subdivision, hammering will drive you bat crap crazy.
Or
The experience
Todd
that.
Tuckle drilling wells.
Yeah.
Well, I've lived with that for 3 years.
So we'll discuss that at a later time.
I just wanted to comment.
Yeah.
What, could we just describe for everybody what impulsive and intermittent means?
Yeah, as John had brought that up before, so I did find some definitions for that. And those are again posted on the website for you to look at. Noise has 3 different definitions, sub-definitions. Continuous noise is a steady sound level that remains relatively constant over a period of time. Impulsive noise, a sound of short duration, usually less than 1 second, with an abrupt onset and rapid decay, such as from hammering or gunfire. That was what John was referring to. And then intermittent noise is a noise whose levels increase and decrease rapidly with time, such as from passing vehicles or machinery cycling on and off. So those are the definitions. And we can look at the language, look at the definitions, and do some more work on that.
Ms. Roy, I saw a hand.
I just wonder, we're establishing all of these criteria, how are these criteria then enforced?
Typically through complaints run through the code officer. And he has dealt with this on gravel pits, shooting ranges, and construction sites.
Yeah, I guess the neighbor complains, or somebody in the vicinity complains. Although I don't know, the one place that I know blasts in town has actually got praise for following the rules and giving notification to people, hey, I'm blasting at 10 AM. And the fireworks people are very good, at least most of them, at saying, hey, I'm shooting them off between 9:30 and 10. And I get it, people with dogs, people with horses, that's a big issue. And so
You know, I understand that, but I don't wanna automatically, create an issue.
And just say one, on construction sites, lots of times, especially during the summer, they like to get going early in the morning because it's cool, especially roofing. Now you're telling them they can't start up a compressor until 7 o'clock.
Okay, okay,
6:30 just, you know, it's bad enough at 6:30.
okay, I will,
Lots of guys would like to be on their job at 5:30 to get up on the roof before it gets hot.
And just to clarify, this doesn't say you cannot be on site doing construction, it's just looking at the construction noise, so.
yeah, I, just throwing it out there, I think it's hard to be working and not make noise.
Well, you could be setting up,
You'd be surprised.
It's not the noise on that lot, it's the noise from someone else's lot. Their property for it.
but you can.
Yeah, I mean, that's open for, I'm throwing it out there for discussion with the planning board, your thoughts on, going back to 6:30, I think is what it was originally. 6:30 to 9, 6:30 AM to 9 PM.
I don't know what brought me to one.
We can have a discussion on
Okay, we'll take that under advisement, and
Most
that's,
guys,
we're not blowing you off.
you know, most guys realize that, you know, they're not gonna be hammering hard at 5:30 in the morning, but they like to get there and set up.
Yeah, and again, it's, I guess this precludes any work. Now, it doesn't matter if you're, you know, if it's not making noise in the property line, it's, or enough noise, so, but no, I mean, I think that's worth discussing.
And again, just to clarify, they could make up to 55 decibels of noise before 7 AM.
I'm reading it, maybe I'm wrong, no construction, to me, means no construction near residential uses from 9 PM to 6:30 AM. So, you know, that, I think we either clarify that.
Yeah.
Or let's go back to 6:30. There's no construction, I mean, construction to me is setting up and doing all those other kinds of, it's all part of the work, construction job.
Is the
Yeah,
construction site classified as commercial?
Not, unless it's commercial use.
So we could, it'd be residential,
I'm sorry.
it would have to be, would it not be commercial? That's a good
No, I guess
point.
that would be a residential situation, so they'd be at those kinds of limits. So we can clarify no construction noise in excess of those nighttime limits, for example, would be a way to clarify it.
Before,
Don't have to decide.
before whatever, 7 AM.
Yep.
Okay. We'll take that under, if it's not blowing you up, we'll take it under advisement and discuss it next time. I'm using big terms tonight. Ms. Roy,
Just one other exemption that you might wanna consider, even though this feels necessary logistically, or logically rather. But the school, I think it might be worth discussing an exemption for noise for the school. Because if people potentially moved here and then all of a sudden the taxpayers are in a situation where they may have to be paying for some sort of buffering or mitigation because the noise from recess is then impacting people that might move here even though the school already exists there. But then this creates no pathway for that noise to be able to exist,
so it's the noise coming from the school.
right? Like the playground at recess with the kids outside, and I know that seems crazy, but you know,
It's not
That-
really.
Well, that's, my concern on all of this is that it's crazy until,
right?
uh,
I'm just saying, if there was, like, the
somebody-
the taxpayers would end up in a situation where they were having to pay, right, to create the noise mitigation from recess if that wasn't exempt from this
we will
list.
take that under advisement. I mean, that's not a bad,
I can
a bad idea.
It's like
I can hear
Right.
voices.
building a house right beside a speedway and then all of a sudden thinking the speedway's gotta go because you built your house right beside it.
I had to really try
Because it's
to.
covered.
Yeah, there is buyer beware, I mean, but that doesn't always apply, you know, it depends on who the judge is and stuff. But again, not blowing anybody off, but that will be part of our discussion. Anything else on noise? Seeing none, Mr. Lamarge, I think we're on to something else.
Fire protection, water supplies.
Yeah. Please.
So this is a response to a request from the fire department, who, they expressed concern with underground water systems not being viable for the fire department to use and maintain. And so currently under the ordinance, a developer is allowed to put in a water cistern, underground or above ground. They can put in a fire pond with a hydrant, or they can put a dry hydrant on an existing farm pond or stream. And if they put in water cisterns or fire ponds, they can get a volume reduction through putting in home sprinklers with the approval of the fire department. So the proposed changes, again, based on the fire department concerns for cisterns, those would be eliminated. And as the planning board discussed with the fire chief, the options for developers, board ended up saying that either a fire pond, newly constructed fire pond, an existing water source with a hydrant, or sprinklers would be equally acceptable under the ordinance. So that would expand the options for developers while eliminating cisterns. That's the proposal.
Any public comments?
Just a clarification, would it still be?
Would you just say your name again,
Oh,
please?
sorry, Mike Abbott, Gary Lane. Would it still be a requirement, would it still be a reduction, a volume reduction through the installation of sprinklers? Or are you saying it would be, as long as they have sprinklers, they don't need any other fire protection source?
As long as they have sprinklers, they don't need any other water source.
Any other questions, comments? Planning board?
Good discussion with Chief on this one, so.
Yeah, I was gonna say chief is on it, and this is one that comes up just about every time we do a subdivision, to be honest with you. And, so this just gives the developer builder the opportunity to, and it's not just put it in, it's gotta meet all the right specs and all. So the code guy, will make sure that, the water draw and all that stuff is good enough. Okay, seeing none, we'll move on to marijuana growing facilities. So I'll start this one if I could, recognizing the town voted down marijuana growing restrictions over 4, 5, 6 years ago. And I won't call it an end around, but there is an exception that in the state law, that George will explain, that we think some folks, and I hate to say take advantage of, because it means they're, doing something wrong, but what they've been doing is legal. We're just gonna try to see if the town wants to button that up a little bit. So Mr. Tavares, if you would.
So as John made reference to, the state, probably 4 or 5 years ago, changed the state laws to legalize marijuana. And there are basically 3 classes: personal use for medical and personal, and then there's recreational marijuana. Many of the stores you see developing across southern Maine, marijuana dispensaries for recreational purposes. And then there are growing facilities, both recreational and medical. So under state law, a community can regulate those uses or opt out. If a town opts out, they're not permitted in the community, which is Durham's situation. However, under state law and personal use up to a certain number of plants, if you're an individual homeowner and you're suffering from cancer, for example, you can have 3 flowering plants, 12 mature plants, and unlimited seedlings. But they must be secured and screened from public view. That's the exemption in the state. However, if you have a farmer or other property owner who has a greenhouse, and they have friends that have marijuana plants, it's unclear whether if each individual person who may be renting space in that greenhouse can have their 5 plants there, then in essence you can aggregate it and end up with what is a marijuana growing facility without either state regulation or town regulation. So the town attorney pointed that out, that is a loophole, and so the intent of the ordinance is to try to just clarify how that would be handled. And either make it outright prohibited, which we're not sure you can do, or at the very least, have it be a conditional use permit that gets reviewed by the planning board with standards. And currently, there is no oversight at the local level beyond the state rules, and this would give the code officers some authority to inspect and apply standards for those uses if they're gonna be happening indoor. So that's the proposal. We're still working with the town attorney to come up with specific language, but that's the policy direction that's being discussed.
And just before we open it up, there's a couple of things. One is there's a belief that people are in fact doing it. And then the other one is the attorney is going, it's a legal nightmare, challenges, all that other stuff. So the attorney is gonna, if we go this, is gonna write language that'll go before the town that we believe will pass scrutiny. So, but what you see now, would you like to comment on it? Your name, please?
Rebecca Polster, Meadow Road. George, I don't know if you can answer this, in terms of, in other towns or state law, are growers subjected to different taxes than as a, like, quote unquote business versus a resident who is growing, or what are the tax differences?
I do not know taxes.
Okay. Just, because if it's considered a business that can be taxed separately than a resident who is just paying their normal taxes, that's my question.
Well, typically, let's just say someone has a greenhouse, and as John said, this has been an issue. I mean, they're based on the value of that. It's saying there's not a commercial tax rate on property and a residential tax rate, it's just a property tax rate.
Right.
So,
But if they are using it as a business, like other businesses in town, their taxes are different.
No.
no.
Okay, well, never mind. Alright. Somebody can say.
Mike McGarrett's Lane, so it sounds like this is just a way for the town or the code enforcement officer to determine whether a growing operation should in fact be a licensed growing operation. It's not that the town is going to create new requirements for commercial operations, it's just I mean, I'm just asking, is that the purpose behind this?
Yeah, I think the intent is to say, look, cannabis cultivation facility, aggregated medical use, that's what I was just describing, okay? If that, I mean, the voters of Durham have indicated they don't want to have these in their community. However, if that is exempt under state law,
Right.
and it passes under the screen of the state, then if the town cannot prohibit it, then at least make it a conditional use,
Right.
where some rules can be applied along those, facility size, can't be a 60,000 foot facility, those sorts of things. So we're gonna try to come up with some either definition, prohibition, and or some standards, and would have to come to the planning board for conditional use review, like other commercial uses.
Right, and so has the attorney or you as a planner looked at other towns in similar situations and what type of codes they put in place for this?
Yes.
Okay.
Before we go on, I clarify maybe just for me, but this isn't gonna be a commercial operation
Right.
if we do that. This is, I have a greenhouse and I'm gonna grow my whatever number of plants are that are legal here. And my neighbor comes over and says, I'm not having luck growing
Right.
my patient care marijuana in my backyard, can I get some space from you? But neither one of them can sell it to
Right.
somebody. I just wanna make clear, it's
Yeah.
still for, personal / my mother's ill or
Right.
whatever it may be.
But you're trying to make sure that story isn't used to create essentially a de facto commercial operation and go under the radar.
Yeah.
And that is, yes, that is all, if it starts legitimately,
Right.
there is a hope that it will stay that way. That Joe comes in and gets his approved, if this is approved, Mary comes in. Now, it may be that somebody's got 4 kids and each of them, are tending a garden, but that the intent is personal use. So, Ms. Roy.
That sort of answers my question. Wondering, I don't know anything about this, so if my question is silly, I apologize, but how does like agriculture play into this? Because I don't think you have to get a conditional use permit for an agriculture use. Is the difference between, because this wouldn't be sold? I guess that's what my question would be. And I'm asking to clarify that because I think that could potentially create another loophole.
Yeah, and as a matter of fact, some research I was looking at today is looking at the need to clearly define what is agriculture. And this could be specifically excluded if the intent is to say not allowing this as agriculture.
Yeah, this is specific to the product. So if for some reason down the road, the town decides that they don't want tomatoes, they could do the same thing, which is you can't go next door to your neighbor and have 5 tomato plants, because we don't like tomatoes. This is all about marijuana. So. Any other questions? And let's see, I think we got one more.
We do,
2 more.
we get easier as we go.
Yeah.
So manufactured housing and accessory apartments. So as John indicated at the beginning, currently, the town allows, tiny home as a primary house, but it would not be permitted as a standalone accessory dwelling unit. Under state law, they have to be allowed, and so this is proposed. This was actually going to be under that legal technical changes, but the planning board felt that these are all just what is required by state law. But the planning board felt that given the significance of this, it probably ought to be put on for at least some public discussion, even though the town doesn't have any options to vary from it. Again, currently, the ordinance requires if you're gonna put an accessory apartment on your property, it has to be either in your existing building attached to it, or in an outbuilding like a garage or a barn. The state law does not allow that restriction, and the town will comply with state law by changing it to allow standalone, either an accessory apartment or a small building. Mobile homes on individual lots under Durham's ordinance must be at least 14 feet wide and have a 312 pitch roof. State law restricts that so that any manufactured housing unit, mobile home, modular home, or otherwise that meets state licensure requirements must be allowed on an individual lot, and you cannot require a roof slope steeper than 212 pitch. Mobile home parks, currently Durham requires at least 20 acres to do a mobile home park. Under state law, you can't require more area than the mobile home park needs and the associated uses around it. So if you can do it fit it on 10 acres with what you're proposing, that would have to be allowed. Minimum lot in a mobile home park currently is 40,000 square feet, almost an acre of land. And it has to be at least 200 feet wide. State restricts that to 20,000 square feet with septic systems, and you cannot require more than 100 feet of width. And if you have a central sewer system, say a massive septic system that serves 10, you can go down to 12,000 square feet and 75 feet of frontage. Currently, the ordinance requires the same road in a mobile home park as you build in a subdivision. State prohibits that. Cannot require more than a 23-foot right-of-way and a 20-foot road width. And finally, town says you must be underground if possible. The utilities, electrical poles and wires state says you must allow overhead electricals to make housing affordable. So again, all of these are intended to say that the town must comply with state law and the ordinance is being changed to comply with state law.
And this is all part of the, create more housing availability, so it's, it's a follow on to that. So, I will open it up to public comments, questions, Todd?
Todd Willier, Stackle Road. Right of way doesn't have to be any more than 23 feet wide,
Under state law, that's correct.
so you gotta get your ditches and your, everything inside that right of way, correct?
Under state law, yes.
So it's not gonna be a 20-foot wide road. There's no way you're gonna do that and build ditches and everything in 23 feet. You only got 1.5 feet on each side of a 20-foot road, so it's gonna be a 12, 14 feet wide road. Fire chief's okay with that?
Probably not,
I didn't think so.
but that's state law.
Yeah, it may create a situation where they can't do it, or, a lot of places don't have, I mean, here, what you're saying, Todd, I don't disagree with it, but that may be the reason they can't do it,
Or they could put in curb and gutter and
Yeah, it
get
doesn't,
within.
yeah, I mean,
23
or they just may say, I can't make that work.
What are you gonna do, tell them you can't have a mobile home park because you can't have a right of way more than 23 feet wide?
No, it doesn't say you cannot
We just
have it,
require
you
it.
just can't require it.
Okay.
Does that answer the question?
Yeah.
To your satisfaction or not?
212, a 212 pitch and a mobile home is kind of a laugh.
I doubt they asked any builders when they were doing any of
Yeah,
this, but
but they do.
that legal statement can wait for another time. Any other questions? Ms. Roy?
So the state law says that we cannot require a right of way to be more than 23 feet for a road in a mobile home park, but we can require, and we do require, a 50-foot right of way for a driveway to a back lot.
Correct.
And the
That's
state,
not a mobile home park.
right, but so the state has this reduced right of way for multiple dwellings
No.
In a-
This is specific to mobile home parks.
only,
Correct.
but a single lot, that just feels like a conflict. That why they would allow a 23-foot right of way for many homes, but we require a 50-foot right of way for one home.
Well, as Todd pointed out, it should be 50.
Right, Yeah.
But the state has said you can't require more than, and a lot of this is in urban situations, like Saco, Biddeford. And there they have underground drainage, so they can fit the 20-foot road within the 23-foot right of way. And that's what the mobile home manufactured housing industry has lobbied the state to get this type of development allowable in towns where towns don't allow it. And so that battle has been going on at the state level for 40 years now. And this is where it is right now.
And I think the state sees mobile home parks as a way to assist in the housing shortage.
Yeah.
Versus 5 acres is not a major plus to the housing shortage. So they haven't really put any thought into that process. And again, if they can't make it work, to Todd's point, if we say, okay, you can do 23 feet, but you gotta make all this work, then they can't do it. They may have to go to 24 or 25 or 50 or something like that.
Or 30.
We just can't start off by saying you have to have 50.
mm-hmm.
What physically works may be something greater than 23. As they engineer and do other stuff.
I just wonder where we get with 23, so specific.
You do, I don't wanna start that discussion.
Mike Abbott, Garrett's Lane, on accessory apartments. So an accessory apartment allowed as a standalone unit, wouldn't that be a house? I mean, how is an accessory apartment in its own building an apartment anymore, or an accessory anymore?
Typically, it's smaller, and under our ordinance, it can be no more than 50% of the floor area of the main house.
Okay.
It may be terminology, but yes, it is a standalone house, tiny house, whatever it
So
may be.
it's almost the same as a tiny house.
Yeah, I mean,
Are there
it-
any, like, is there anything, how close does it have to be to the main building? What if it's a quarter mile away, you know, is that?
As long as it fits on the same
On the
lot.
same property, it's
Yeah.
allowed.
Okay,
The law restricts the ability, or whatever you wanna call it, to put a lot of restrictions
right,
on this. I mean, you know, to say, hey, you've gotta have 28, you got 2 units and that requires 10 acres
right,
or
right.
whatever,
this
we
is
can't do that.
So this is allowing, but you mentioned there's limitations to the size as compared to the original house?
Yes, 50%.
And that's, I think, the state law, if I remember.
No.
It's not, it's just our.
That's the town, okay, thank you.
Just in the town.
Any other questions, sir?
On an accessory apartment, and if it's gonna be a standalone unit, at what point is it gonna get sold as a separate unit? But it's on land that's owned by another person.
I could break apart the lot.
Yeah, I'm not sure, this is intended for not, you know,
Well, does an accessory apartment have to be owned by the person that owns the land?
Unless they create a condominium.
So an accessory apartment can be sold off as a separate unit.
Condominium, potentially.
I don't know much about tiny homes. Do they have to have their own septic system?
Yes.
Septic system required by a full-on septic system
Whatever the main state plumbing code requires.
for a tiny home?
yeah, for that size.
Is there a different restriction, a different?
I don't know what the plumbing requirements are, it's probably the same as a single bedroom home. But they may or may not have special standards for tiny homes for septic systems. But they do have to have a septic system.
It's interesting because
But I think, can they tie it into the existing homes?
If the
If existing
existing
home
septic
system
system
will
has
accept it.
capacity, yes.
They could, so they don't necessarily have to have a standalone if they can tie it into the existing,
Yeah.
tank and drain field.
but most times it'd be far enough away because yeah. Interesting.
Any other questions on tiny homes, manufactured housing, or accessory apartments? Going. And planning board,
Well, I mean, and your kind of title is one state law, so it's gonna be clear.
And the town attorney is looking at this one with us, so we're gonna make sure that we do what the state requires.
So, any other discussions? Seeing none, I think, Mr. Thamarj, we've given you some guidance, things we've heard from the folks and from internal. Am I missing any other topics for this evening? So there's a big list of, the November 15th, there's more coming.
Is that date correct?
What's that? Is that the correct date?
November 15th.
It's a Saturday.
Okay.
November 15th is a Saturday.
Well, when you retire,
It's the 11th.
the 11th. Thank you for checking.
12th is a Wednesday.
Well, sorry.
So the November 12th, so those of you who've already left the TV, November 12th.
November 12th.
Here, 6:30 PM. And it'll be on the blast, it'll be, you know, on the webpage, so it will also be out there some, and I apologize. Ms. Roy?
Do you know at this time, or can you tell us at this time, if the planning board is considering a fireworks ordinance?
We're gonna,
I know I personally went to the select board when there were some issues about it, and they were not suggesting that the planning board create one. They were, basically, I think they had ruled on, we were gonna be following, we being the town's gonna follow the state requirements.
I remember the same thing, I think 3 or 4 years ago, shortly after I started doing this, went to the meeting, the same thing. They said we follow the state law. And so, as I mentioned, the state law is mostly about hours and then how many tons of explosives you can set off at once and some other stuff, so.
Just at once.
Well, you can, if you have a microsecond, it's an intermittent surge.
One more question, you mentioned at the beginning that there's two public information